thanks very much to the organizers of this group and to Senator Krueger for inviting me here, and Victoria Pitts-Taylor, and all of the people who made this evening possible. But I'd also like to say, having heard that fantastic talk, that I wish I had reframed my own slightly. I'm going to tell you 3 stories from 3 different legal cases that have been in the front of my own scholarly thinking of late. And having heard what Amy just had to say, what I'd like to flag for this is, throughout all of these tales, you will see the ways in which, legally at least, masculinity is masked and kept out of the public domain and hidden and protected in very careful legal ways that damage women in exactly the mechanisms that you're speaking about here. I'd also like to foreshadow the fact that while I was focusing on the technological elements of these cases, I think that makes an interesting bridge to the conversation that is going to follow where I go. So here are my 3 tales. The first, the tale of Marisa Miller. In October of 2008, school officials in a small town in Pennsylvania confiscated the cell phones of several students and discovered there images of scantily clad, semi-nude, and nude teenage girls. According to a trial court's opinion, the photograph in question of Marisa Miller was approximately 2 years old. It showed her and a friend from the waist up, each wearing a white opaque bra. Marisa was speaking on the phone, and Grace was using her hand to make a peace sign. The girls were 13 years old at the time the image was taken. School officials turned the phones over to their local district attorney, a fellow by the name of George Skamonic, who began a criminal investigation in order to stop sexting in his jurisdiction. One of the key points of contention here arose from the question of whether or not these qualified as images from child pornography. The parents argued that none of the images showed any sexual activity, none of them showed the girl's genitalia or public area. Sorry, is there?
A little louder.
Now I'm very intimidated. Is that better? Have we achieved your objective? It's slightly alien, but none of the images showed any sexual activity, the girl's genitalia, or any pubic area. Skamonic, on the other hand, the district attorney, contended that the provocative poses included in the images qualified them as pornographic. He refused to give the parents copies of the photographs, arguing that doing so could subject him to distribution of child pornography charges. The girls contended that they had not sent the photographs to anyone else, but that a third party, a male classmate, had stolen them and sent them to a large group of people without their permission. Skamonic sent letters to parents informing them that their daughters would be charged with the possession and or dissemination of child pornography unless the girls completed an education program that was to last 6 to 9 months. That program was designed to teach the girls, and I quote here, to gain an understanding of how their actions were wrong, to gain an understanding of what it means to be a girl in today's society, both advantages and disadvantages, to identify non-traditional societal and job roles, and they were to complete a homework assignment on what you did and why it was wrong. All of the parents agreed to participate, except for 3 who brought this litigation forward. Their complaint alleged violations of their First Amendment rights to be free from compelled expression, violation of their First Amendment rights to free speech, and their 14th Amendment rights to bring up their children as they deemed appropriate. Ultimately, they were successful. Notably, the individuals who circulated the images, the male classmates of Miller, Kelly, and Doe, were not threatened with prosecution. This final point is what was ultimately dispositive at an appellate court level. Judges there concluded that the girls' appearance in these images did not demonstrate that they had produced or distributed what we might or might not think of as child pornography. The second case. In May of 2011, the Texas legislature, like many others have done in recent memory, amended what they call the Women's Right to Know Act, ostensibly in order to strengthen the informed consent provisions for women seeking abortions. The newly amended rule requires doctors to do 3 things. First, take a sonogram of the fetus and display it to the woman. Second, make audible to her the fetus's heartbeat. And third, to explain to her the results of both examinations. A woman could refuse to see either the sonogram or hear the heartbeat if she chose to do so, but she could only forego the doctor's explanation under one of three sets of circumstances. First, if the pregnancy had been the result of rape or incest that had been reported, or if it were not reported, because the woman reasonably feared retaliation resulting in serious bodily injury. Second, if she were a minor taking advantage of a judicial bypass procedure. Or third, if the fetus had an irreversible medical condition or abnormality. The amendment also required a woman to wait 24 hours between that examination and having an abortion. A district court struck down the disclosure provisions, but the Fifth Circuit overruled that decision. In a subsequent decision following the guidance of the appellate court, the district court judge, Sam Sparks, upheld the new amendments, begrudgingly. It's a tense opinion and very interesting to read. Part of the conflict between these two courts arises from a definition of the word ideological. The district court characterized the disclosure requirements as an imposition of the state's ideological position and determined that it was compelled speech in violation of the First Amendment. The Fifth Circuit disagreed. Dismissing the claim of ideological imposition, the Fifth Circuit concluded instead that such medical descriptions are, and I quote, the epitome of truthful, non-misleading information. The court found that these disclosures were not different in kind, although more graphic and scientifically up-to-date, than the discourses required and upheld in recent Supreme Court jurisprudence. The Fifth Circuit went on to explain that, quote, denying a woman such up-to-date medical information is more of an abuse to her ability to decide than providing the information. My third story. Also in May of 2011, Operation Save America, a Texas-based anti-abortion protest group, arrived in Jackson, Wyoming, to protest at the offices of Dr. Brent Blue, who the group claimed was the only abortion provider in Wyoming. On the morning of Wednesday, May 18th, the group, approximately 20 members strong, assembled at the Jackson High School and Middle School, where they handed out flyers calling Dr. Blue a killer. They held up large photographs, approximately 4 feet square, showing images of disfigured and dismembered fetuses. In one incident, an Operation Save America member boarded a school bus filled with children, showed them the images, and asked them if they knew that Dr. Blue was a killer. The town of Jackson obtained a temporary restraining order against OSA, hoping to prevent them from disrupting that weekend's planned Elk Fest, which threatened to draw 200 Boy Scouts between the ages of 7 and 14 into Jackson. Operation Save America appealed. There was a great deal of discussion in the opinion as to whether or not it was moot because the restraining order was in place and it kept them from protesting that weekend. But the Wyoming Supreme Court ruled anyway and concluded that the restraining order was a violation of Operation Save America's First Amendment rights. Of particular note is the court's construction of what may cause irreparable harm to children, and here I quote. Our concern in the present case is not with the general proposition that protecting youth is a compelling government interest, but instead with the record. The record contains no evidence concerning the injury or potential injury to children from viewing the images displayed by OSA, and particular importance in the context of the request for injunctive relief, evidence of irreparable harm to those children. In the absence of such evidence, the government has not made its showing of an actual problem in need of a solution. There are many things we might say about these cases. I've mentioned a couple of them already, but here's where I'd like to conclude. I want to focus on 3 particular elements that I find troubling at this moment in the war against women. First, I think we should linger for a moment at least over the problem of proportion and to contemplate how dangerous it is or is not, and to whom, to reduce life-sized women of whatever age to fit onto a 3-inch screen. At the same time, I think we should pause to think about the fact that it takes a great deal of technological intervention not only to capture the image of a bean-sized fetus, but that it must be magnified hundreds of times in order to fill a computer monitor or a poster 4 feet square. We need to be reminded that speech only becomes a problem when some communicative act disrupts a peaceful relationship between a speaker and an audience. Miller, Kelly, and Doe defined a community among themselves, serving as both speaker and audience. The problem arose when their communicative acts were stolen and reproduced outside of their own community, expanding their unintended audience and seemingly traumatizing the local district attorney. We need to position that moment of trauma alongside the trauma that is disguised as informed consent contained in the Texas Women's Right to Know Act, as well as Operation Save America's protected right not to traumatize school children, but, in the language of the court, to keep them informed on a matter of great public importance. And third, we need to think anew about the many forms of communication that are lumped together under the heading of free speech. There's much more at stake here than the freedom to send a message, or whether those messages are sent freely or compelled. The bigger problem here is the issue of whether or not one might choose to receive or avoid that message. Because in the end, while we might debate whether or not adolescent bodies are pornographic, or whether or not the contents of a womb might be made so, what these cases illustrate are the ways that women are punished for exercising agency and taking control of their own bodies, and in the circulated representations thereof. As you Sedgwick pointed out some time ago, the bigger problem here for us lies with the question of who gets to control the terms of that circulation. Thank you.